Indiana, down by the
He's a whack job.
River.
What's he up
We
to?
had 7 miles.
He doesn't do anything. He never did anything.
11
He
miles.
doesn't really have a job.
Evansville. That's where the.
He just makes anti-Scientology videos.
Yeah, I know. I couldn't believe it. I was just a little.
That's it. I think we have to wait for the video. There we go. Today's meeting of the Municipal Code Enforcement Board is called to order on May 25th, 2022. Welcome, everyone. Please rise for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated. Agendas of today's meeting are on the wall at the entrance to the chambers. Please remember to turn off your cell phones. The Municipal Code Enforcement Board consists of 7 members who are appointed by the City Council. We serve voluntarily. It's the board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method of enforcing certain codes within the city. The board considers new business items in 2 parts. First, the violation, and then affirmative relief. Formal rules of evidence do not apply. Each side is limited to 15 minutes. The board may grant additional time. All proceedings will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, they will be escorted from the chambers. Now I ask all who plan to speak to please rise and be sworn in by the clerk. Thank you. Our first order of business is to review and approve the minutes of last month's meeting. May I have a motion to approve the minutes?
I'll make the motion to approve the minutes. I'll second it.
And minutes are approved. All in favor? Aye. Now they're approved. Takes me a few minutes to get rolling. All right. Is there anyone here to speak to anything not on the agenda today? Anybody? Okay. So next on the agenda are the new business items. The first one's withdrawn. The second one, is this one continued? The
4.1 has been withdrawn.
withdrawn 4.2? Is that
4.2 has been continued.
That's continued to
to
July.
July.
Sorry. And then, okay, so we're starting with case 3222.
Yes.
Fines respondents Coachman Creek Condo Association at 2625 State Road 590, Building 5 in violation of code for unsafe building. Hi.
Hi, how you
We've
doing?
been here before.
Jason Cantrell, Building Inspector, City of Clearwater. This is for the property at 2625 State Road 590, Building 5. This was heard last month and found in violation, but I guess we need to redo the board order for this month. Do you want to see photos, or do you want the whole case presented?
I think this was just, since it was a technicality, we can just skip to the end.
Okay.
And then we'll re-rule.
Okay. I'll just show you the photos real quick just so you can see. This is the one that had the shoring and bracing installed at the condo complex.
So for our piece, they've already admitted to the violation, but are we gonna speak again? Is there anyone here to speak on this?
Yes.
This is to determine what kind of time period and the second part of the fine.
Well, this is on the first motion.
Yeah, but it was missed, so we need to read it.
Okay, if you could redo the first motion, please.
Okay. Well, he wants to speak. So.
Good afternoon, members of the board. Adam Gurley on behalf of Coachman Creek. At the last meeting, we did admit to the existence of the violations and discuss the association's plans to remedy those, but we did admit the violations at that time.
Okay.
Thank you.
Thank you.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
A second.
All in favor?
Aye.
Aye. You heard it. Everybody heard it.
Who is the second?
I second.
Please second audibly.
So what's new?
So, we did get a letter from their, from the engineering company stating that, the building would be safe to occupy during the shoring and bracing of this, structure. So that's what we were waiting on. They also did apply for the permit for the shoring and bracing. They haven't applied yet for the permit for repairs, but that would be, coming up shortly.
Why is it taking so long to ask for that permit? I mean, how long has?
For the permit for repairs, you would have to ask them that, but it's an association that they're dealing with, so that tends to
Oh, yeah,
make things a little
I think they
longer.
were getting quotes.
right. Maybe the petitioner could.
Absolutely, thank you. Be happy to address that. This is the one where the association both had a plan for the short-term fix, which was the shoring both to the back balconies and the front walkways to address any emergent issues and make sure the building was safe to occupy. It was this board's order to have that done and obtain the engineering report that confirmed that the building was safe to occupy. I think it was within 7 days. It was by May 5th. We hired a second contractor, worked through the weekend, got that work done, received the engineering report by the 5th that we provided to Mr. Cantrell along with photographs where the engineer signed off and said, everything it's safe to occupy. I'm checking this property on a weekly basis and will continue to do so moving forward just to address, anything that may arise. So we've accomplished the short-term goal. The board is still very much aware and very much willing and in the process of addressing the long-term fix, which is the greater project where they've engaged Suncoast Restoration to do the long-term repair. This is the case where the association, one has the pending insurance claim against their insurance company that was denied. So now they've approached a lender to get funding for the $500,000 plus project. And they're currently in the process of, we have the contract with the contractor for those long-term repairs in our hands. The engineer gave it to us. Our law firm's reviewing that and putting together an addendum to try and get under contract. But before we can formally do that, we have to make sure the financing is in place. At the moment, if it's emergency repairs, then the board can vote to take on that loan. If it's not considered emergency repairs, then the membership has to vote. And that's kind of an issue that we're working with them at the present moment. I don't have an answer as far as which path that's going to go down as I stand here, but that's the reason for the delay is both the funding and then the contract portion.
So are you the one that's trying to assure that it's an emergency repair? Are you the one that's making the case for it being emergency repair? Or?
In working with the engineer, we're going to need an engineer to kind of to go down that path. Legally speaking, I can't, opine on whether it's an emergency within their governing documents, but once their engineer opines on that, then that's when we'll get with the board and say, okay, based on what they said, we think you have a right under your documents or you don't have a right under your documents to move forward solely on a board vote. This has to be a membership vote.
How long do you think that's going to take?
To get that decision, I think, is within a week. I mean, that's not going to take long to get an opinion from Scott, the engineer, and then to get with the board, to get that board meeting to vote it through and then move forward with the financing aspect of that. I'd be throwing darts at the wall, to be perfectly candid with you. There's a couple lien issues that the lender was concerned about last I was involved in that conversation that we're working through. So I don't, again, have a great timeline for you. I'd be kind of just throwing numbers out there if I tried to give one. But we're pushing this thing forward both to get the financing. We have a contractor picked out. The contractors worked with us to do the temporary stairs to allow the owners ingress and egress. So it's a cooperative, cumulative project, but there's a lot of moving parts at this point. But in the interim, the building's been certified as safe for occupancy.
Oh, that's good. That's good to hear. Troubling situation. Any other questions, Attorney?
Thank you.
Just want to skip to the,
So for compliance to be met for the unsafe structure, we're asking for them to apply for, obtain, and complete the required permitting for repairs. This slide was from last month. I did not change the dates. We were asking for 60 days, it looks like. So that could be, I suppose 60 days from today is what we would stick with, and then we'll leave that up to you to decide.
Is that sufficient time? Is that what we touched on last time?
Mm-hmm.
And I don't remember what we decided.
We had given, it was 90.
I know we talked about the timing to do the short-term repairs to make sure it was safe for occupancy. I don't remember a discussion about the timeline for the long-term to actually get work underway and have the permit submitted. What I would ask, if the board is agreeable, is to give us 60 days to continue down the path we're on with every intention of acting as expeditiously as we absolutely can, and then to report back at 60 days. I, as much as anyone, and the board, as much as anyone, hopes that that report is, we're under contract and a permit application's been submitted. I just can't, say with any absolute confidence that that'll be the case in 60 days, but I'd be more than happy to come back before the board and explain what we've done from this day to that point in time.
I'm good with that.
Ready for a motion?
Well,
That's what the 60 days is for. You give them 60 days and they can.
I mean, like if tomorrow.
We need audible discussion.
yeah, I realize that.
They have someone on emergency to call and handle.
I know, but could the inspectors be informed about that emergency if something does come up, so in case we need to, before the 60 days?
Our,
I don't know if that's our,
role is regarding this permit
Permit.
and,
yeah.
Correct.
and the completion of this permit. I mean,
Not the
whether or
safety
not,
of the
if they
building.
cannot complete it by that timeline, then the fines begin on this building, on this association.
Can we make it 60 days, but yet have them come back next month to explain where they're at, just to give us an update? Or is that just over?
I don't think we need that in between.
I mean, you could do pretty much anything regarding that, because otherwise you're implementing a fine. I'm sure
Right.
they'd rather come and tell you what's going on.
Yeah, we've got up to 60 days of that.
So they have to obtain a permit by May 27th. What if we change that to July 27th? And then the second one is completing the permit. I mean, that's the construction, correct? So the construction's going to take, what, another 60 days?
I would say in that range, yes, sir.
Yeah, we can do that.
So we can have obtained the permit by July 27th, and whether 27 is the right number or not, and then have it completed by September 27th. Yeah, well, they got a lot of things.
We can certainly make that
Okay.
motion.
Okay, so what did you come up with?
They think they'll need the 60 days for the permit. My recommendation to you would be to reset this for the July meeting, to ask for a status update on both obtaining the permit and then the time period for construction.
So the motion would be to have the petitioner obtain a proper permit on or before
July 20th.
July 27th, and then complete the permit by September 27th.
Well,
That's up to you. I thought what you would do is say the permit by July 27th and have them appear
Status
at your
update.
July meeting to tell you where they are on the actual construction time period.
Because we really don't know, and the petitioner doesn't know how long it's going to take to
Right.
fix this. And of course, it's.
I mean, your first concern was safety issues.
Right.
You've now dealt with that. So now the time period, I mean, they could come back and say, we can do it in 60 days, or they may ask you for more time, but that's up to you at that point.
Right.
But I think in this particular case, what you're asking is for them to keep you informed so you can make a decision based on what is going on. If there's no effort in the past, the board has said, okay, that's enough, and we're going to start fining you. If there's effort, the board has worked with the individual.
I agree. We don't want to keep kicking this down the road. So let's make the permit something reasonable the 27th, and then a return for a status update. You can make that,
Okay, I think already.
you can make that
made-
motion.
Okay, the motion is to obtain a proper permit on or before July 27th.
Does someone want to make the motion?
I think I just did.
You didn't
No, you
finish
have
it.
to put
You have to
read.
finish
Oh.
it.
Okay, I move to enter an order that a fine of 150.
You're on the first, come back.
It'll be the second part.
Page 1.
I'm sorry, yeah. I move to enter an order requiring the respondent to correct violation on or before July 27th. The respondent does not comply by that date, the board may order a fine of $150 per day for each day the violation continues.
No, sorry, I apologize.
Okay. Maybe you ought to make the
I
motion.
can't. Let's use this one, and then, let's use, this is not the one. Yeah, let's use this one and have it be, July 27th for the permit, and then return with a status update, and you don't have to, you could leave out that.
Okay, I move to enter an order requiring the respondent to correct the violation and obtain a permit on or before July 27th, 2022. If the respondent does not,
And return for the status update at that meeting.
and return for status report at that meeting, do you want
July
to?
meeting. With the date?
July 27th.
Okay, and the 27th is the July meeting.
That's fine. Can I get a second? I second. All in favor?
Aye.
Aye.
Thank you.
Thank you.
Thank you, members of the board.
Thank you. Okay, 4.4 has been continued to June. Case 33-22 finds respondents Marek Pietreniak, apologies on that name, at 512 Skyview Avenue in violation of code for exterior storage. Is there anyone here to speak to this case? Skyview Avenue? Daniel? Good afternoon.
Good afternoon, Board. Daniel Casman, Code Enforcement Inspector for the City of Clearwater. This is for case number 33-22 at 512 Skyview Avenue. There's one violation here for Code Section 3-1502, G1, G2, and G3 for exterior storage. Exterior storage not for use outdoors, and construction material storage. Notices of violation were sent on September 29th of 2021, and then again on November 2nd of 2021, with a compliance date of October 29th, 2021, and November 7th, 2021. Affidavit of posting was posted at the property at November 2nd of 2021, and the notice of hearing for today's hearing was May 12th of 2022. This is the outside view of 512 Skyview. I've been getting complaints about the backyard of the property, which the owner was storing about 300 tires or so. There was also an issue with the pool at the property. It was full of brackish water. There was also some lumber and more tires and an old water heater being stored. I was been in contact with the owner, who was also the owner of the Pierogi restaurant on Gulf to Bay. So I explained the ordinance, and they took steps to clean up the tires after a certain fashion. There was many extensions. There were many extensions asked to come to conclusion with the tires. This was the affidavits of posting for the dirty pool and for the tires. Went back on the 22nd. They were all still there of November, but then in January they had taken care of most of it. I'd like to point out that fence in the back of the property. There was still some lumber that had to go, but we had been making good progress at the property. And then I noticed through property appraiser that the property also extends back about another 15 feet and got more complaints about the rear behind that fence. And back there is just piles of metal, scaffolding. This is just to see from far away. That's the fence you see closer to the house is where the pool area was with all the tires. But then once you get to that greenery on the right, That's where it extends. I don't know if it was put in some way, but the whole area back there is just full of air conditioning units, random signs, metal. I spoke to them again and explained that that too counts as outdoor storage and that needs to be taken care of. They asked for additional extensions, which I gave because they at least made good on their previous promise of getting rid of all the tires.
Oh, the tires are gone?
All the tires are gone, yes. The owner came by with a big truck and threw all the tires in the truck and took them away. But then, I guess they didn't think any of this was outdoor storage either.
This is beyond the fence?
This is,
Beyond the backyard?
the property sits going east to west. This is the most western part of the property. That fence I'd shown you earlier where the pool was hiding this additional part of the property, which butts up against this property is also right next to the pierogi restaurant, which the owner owns both properties. So I explained to them again that all this stuff also has to go or either be stored indoors or off the property. They explained that they needed time to clean up this area with a lot clearing or hire a contractor to cut out all the trees because it was getting in the way of them moving anything. But no action's been taken. This was in March 23rd. And then here's the notice of hearing for today's hearing on the 12th of May. Then I went back a few days ago and still the same pile of metal. Some things have been removed, but mostly it's still all there.
Does look like they've attempted to clear and
It's
organize.
I've tried to give them time, but it's been going on for over 6 months now, and the progress is piecemeal at best. So we just need a definitive timeline for them to come into compliance with this.
So that white fence in the back was actually mounted like a couple feet away from the property line?
No, it's right in the middle of the property line. The property extends even further back. That back area is like another hidden section of the yard that also boats up to the property end of the pierogi restaurant that's also there in Delta Bay.
Not really related, I'm just curious if anyone is living.
Yes, there's someone living in the home.
And then the pool is still in that condition?
This pool, no, the water was all removed and the pool was filled with dirt.
Oh, okay.
So now it's no longer a brackish pool. It's no longer a hazardous pool.
All right.
So, Frederick, any other questions?
How big is this backyard? We'll say 30, 40 feet? before you get the restaurant?
The section that's fenced in, about 30, 40 feet, but it's, like I said before, extends about 15 to 20 feet even further west on the property, which is hidden by that fence.
Is there a fence between the restaurant and the backyard?
Yes, same exact fence. It's a fence that has a sort of T pattern,
Yeah.
and then the home on the other side.
So it's almost like they built that extra space for storage, because
I just tried to get them on the page that all exterior storage, meaning any items that shouldn't be getting rained on, need to be off the property or indoors. There was some resistance to the tires going, but they eventually took care of it, so.
And there's no respondent here, correct?
No.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second. All in favor?
Aye.
Do you want to, do you have a recommendation?
Yes, so Daniel Kasman, Code Enforcement Inspector for the City of Clear, for case number 33-22 for 512 Skyview Avenue. I'm requesting compliance on or before June 25th of 2022, or a fine of $150 per day per violation for each day the violations continue to exist. We're asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the City Attorney's Office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. And compliance can be met for the exterior storage by removing all items not meant for outdoor use from the grounds of the property. This includes all construction materials, metal, wood, tools, tires, and all other miscellaneous goods or items.
I move to enter an order requiring the respondent to correct the violations on or before June 25th, 2022. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If the fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
A second. All in favor?
Aye.
Thanks, Daniel.
Thank you very much, Board.
Case 41-22 finds respondents WRI Countryside Center LLC at 2561 Countryside Boulevard, Unit Number 4, in violation of Code for Permits. Is there anyone here to speak on this case?
Hey, good afternoon, Board. I'm Housing Inspector Sam Swinton. This is case 41-22. Guess we can give you a little history on this property before I get started with the extra presentation. This is basically just a violation of a permit that they didn't get assigned. However, I'll move right on to the next. They did apply for a signed permit back in October 17 of 2019. However, that permit was voided and they applied for a second permit March of 10 of 2020. And then many of you can remember that's when COVID hit. And so everything kind of stalled. However, our office was never closed. We were closed to the public, but we still were receiving documents and applications. A letter was sent out to the owner of record for this permit on March 20, 2020 to let them know that the permit was ready to be picked up. However, the permit was never picked up, so the signed permit was voided December 9th of 2021, well over a year and a half in the making. So today I'm here for one violation, which is the Community Development Code, Section 4-203.A.1, Section 47.083, Section 2. My notice of violation was sent out on February 15th, 2022. I did receive the certified mail receipt back on February 22nd, 2022. Notice of hearing was sent out on April of 1822, and I did receive the certified mail April 25th, 22. This property is located right across the street from the Countryside Mall and it is called the Country Century Complex. It's kind of where Ross, some of you might know where Grill Mark is in that location. This is what it looked like in August of 2019 after the subway left. And so there's no sign at that property at that time. Just another picture of that unit number 4. This is what it looks like today. And it's Burger IM. Haven't been, but I heard it's good. Another picture of the sign that it was installed. And that's it.
And
So you got the receipts back or the notifications, but you've not been in contact with the...
No, I actually sent everything. All the green cards came back signed from the owner of the property. There is a property management company that I guess managed this property. Haven't heard from them also.
But is that the sign that they originally had the permit
Yes.
request for?
Yes.
Which was granted but voided because they simply failed to pick it up.
Correct.
And we just need someone to reapply for it and...
That is correct.
What's the permit cost? When they pick it up, did they pay for the permit? Or did they already
They didn't.
pay?
No, none of the fees at that time were paid for. It was applied for, approved, but the fees were still.
What's the fee?
I don't have that information with me. I think it was.
Maybe they haven't sold enough hamburgers.
No, they're good. They sell enough hamburgers.
There's no one here to
No.
speak on
With the
behalf.
pierogi people.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
I'll second that.
All in favor?
Aye.
Okay, our recommendation for case 41-22 is work without a permit. Request compliance owner before June 25th, 22, or a fine of $150 per day for each day of the violation continues to exist. We're also asking that the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the City Attorney Office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
I move to add an order requiring the respondent to correct the violations on and before June 25th. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
I'll second that.
All in favor?
Aye.
Thank you.
Thank you, Mr. Swinton. We're gonna move on in the agenda to the unfinished business and accept the affidavits of compliance as listed. Would you like me to read them?
I'll move that we accept the affidavit of
Wait, just one
compliance.
second. I don't know. Should I, do you need them read?
I was gonna read them.
Oh, go ahead.
I was just gonna say-
Apologies.
Compliance that's listed at 5.1.1, 5.1.2, and 5.1.3.
Is there a second?
Second.
All in favor?
Aye.
We've accepted the affidavits of compliance. Is there anyone here to speak on the affidavits of non-compliance, TAH 2017? Anyone on that? Okay. So may I have a motion to accept the affidavits of non-compliance case? Oh, I'm sorry. My apologies. Affidavits of non-compliance are Edgy Properties LLC. Is there anyone here to speak on that? Okay, may I have a motion to accept the affidavits of non-compliance case 147-21?
I move to accept the affidavit of non-compliance and issue an order that imposes fines and states that if fees and fines remain unpaid, after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second. All in favor?
Aye.
Aye. Okay, moving on to the nuisance abatement lien filings.
Two of them are good. It's really just 7.1, 7.2, and 7.4.
For the acceptance?
Yeah, two of them are continued.
Right, you can accept that.
We can accept them all as one.
7.3 is continued to June 22nd, 7.5 is also continued to June 22nd, so it would be the other three.
We review the other three?
7.1 does have citizens to be heard.
Oh, okay, my apologies. Case,
7.1 does? Okay.
case 35-22, nuisance abatement lien for respondents Alfred and Percy Wallace at 409 South Martin Luther King Jr. Avenue for lot clearing. Is there anyone here to speak to this? Can you state your name and address?
Good afternoon, Board. My name is Albert Wallace. My address is 409 South Martin Luther King Jr. Avenue, and that's in Clearwater.
But Alfred Wallace or
Yes.
Alfred? Okay, thank you. And what are you requesting, Mr. Wallace?
I'm requesting that my nephew get that junk out of my yard. I've had several arguments with him about it. I've cleaned, I paid $2,200 to get his junk out of my yard. I went to a rehab center because I had a blood infection. When I came back, he has more junk in there. So I'm requesting that y'all put it on a piece of paper because he can't seem to understand what junk is.
But you own the property, correct? And that's
Right.
Okay. And he has, your nephew, you said, has
Yes.
put this.
And I'm having arguments, but I'm getting stressed out because he won't get the junk out of my yard.
Yeah. And now it's before us.
Right.
And
Which
so,
shouldn't even came to that because when I had paid for the junk to be out the last time, when Daniel sent the paperwork saying that no more junk would be there, I gave it to him. When I came out of rehab, junk was in my yard. We had a big argument. A few days later, Daniel came out there. He's been out there 3 or 4 times, telling him what he can't have. He won't take it out.
yeah. So now the issue is the city is going to remove it and then send you a bill if he doesn't get rid of what's in the lot.
What kind of junk is it? Why does he?
He got all kinds of stuff back there. Chairs, some kind of electronic stuff, he got tents up, he got everything.
Where does he live?
He stays with us.
And is that on the same property?
Yes.
So this is a
Yes,
So you think if you started to remove the stuff or had someone come out to remove the stuff, it would probably cause an altercation?
yes.
Or it will come back. He would
He would
continue.
bring it back, yes. Because if it wasn't, he wouldn't brought the junk when I removed it the first time. And I distinctly told him that I'm not paying for no more junk that he puts in that yard.
So can you evict them? I mean, I know it's family, but it sounds like you have to get rid of him. Can you evict him?
Well, I wouldn't call it a veto. I just want the junk out of my yard. Whatever y'all say, and if he can't do that, then we have a problem.
Okay. Well, let's hear recommendations then from Daniel, and
Thank you.
we'll see what we can do. Thank
Thank
you.
you.
Good afternoon again, Board. This is Daniel Kasman, Code Enforcement Inspector for the City of Clearwater. This is case number 35-22 for 409 South Martin Luther King Jr. Avenue. This is for a nuisance abatement. There's one violation here for Code Section 3-1503B5A for accumulation and placement of nuisances, and Code Section 3-1503B.7 for lot clearing violation. Notice of violation was sent on March 30th of 2022 with a compliance date of April 30th, 2022. Affidavit posting was April 1st, 2022, and the certified mail receipt was received on April 12th, 2022. This is 409 South Martin Luther King. I have been here before for an issue regarding many items being stored outdoors. They did clean up the property. That was back in 2021. But I had to come back out the property again. There's a bunch of townhouses that are across the street, and there were complaints that there were people living outdoors on this property and also on the neighboring properties at 413 South Martin Luther King and another adjoining property on Brownell Street. It's two empty lots. I went by to investigate, and there were indeed people living in vans and vehicles on both properties. I alerted the owners of those properties who had the vehicles removed, and I keep in contact with them about any sort of lawn maintenance over there. But additionally, on this property, 409, it come into non-compliance again with many items being strewn about the property, and I have been in contact with Dwayne, Alfred's nephew, several times trying to explain to him that you cannot run a scrapping operation and you cannot have a commune on the property. You cannot have people living outdoors in tents, and you cannot be scrapping in the backyard. Just not allowed in Clearwater. If you want to, that is the backyard of the property. This was on the 30th of March. They had tents set up. What it looked like was a fire pit back there. Told me the tents were there for the items, that no one was living in the tents on the property. I again explained that you cannot have people living in tents on the property. You can't have all those items outside either. This is just some more photos of the backyard, just random electronics strewn about, construction materials. This is the back of the home where more things are being stored outdoors. I went back on the 3rd of May, and there are more boxes, clothes, items being stored outdoors, tarps. The tents are still up. The person in the photo was one of the people also living next door in one of the vehicles. I've seen several of them at the property before, sometimes just in the backyard on couches or around a fire pit. Again, just every item on the grounds of the property has to be removed or thrown out. They have thrown out some things, but as I come back, more and more, this is just 2 days ago, as I come back, more and more items just appear. They get rid of some things, and then other things reappear. And I've explained to Dwayne the proceedings and how it will work. After a board order, we can just keep coming back and removing items from the property, and it'll be attached as a lien to the property. He says he understands, but continues to operate here like this. So this is just more photos. There's even more items back there where it had been cleaned up. More items have made an appearance. Especially concerning is any appliances like the refrigerator you see on the grounds where children could get inside, possibly get trapped and suffocate. That is one of our greatest concerns, that the property just be cleared of everything that's not meant to be outdoors. Do you have any questions?
Is this right across from like Rita's Italian Ice?
Yes.
All right, well, do we want to make a motion? Does anyone have any other questions?
It's one motion, just one motion for the whole thing.
So this is,
Page 7.
well,
Question
what's,
for Mr. Wallace. Hi, sir.
we do need to get the time.
You need the time?
Well, go ahead.
Okay. Thanks for coming in and just explaining the situation. What do you plan to do with your nephew, given the circumstance and he continues to bring back more debris and store?
Well,
No.
all I can say is, if he gets the junk out of my yard, then we're good to go. I've given him all the time to get it out. He tells me he's gonna get it out, but he never does. When Daniel gives him time to get it out, instead of him getting it out, he sits around the whole time that he's supposed to have to get it out. He doesn't get it out. Daniel comes back, gives him another time. He sits around.
Do you understand the severity of the lien now and what that means with?
I understand, but I'm not the one that need to understand. He's the one that need to understand.
What worries me though is that you're the property owner.
Yes, I know, I understand that.
I don't want anything to happen to you, but it concerns me that he's having a really big impact on your life and your home and everything else.
I understand that.
Is there any request that you have for the board, or you just plan to?
If y'all could give me something to show him that y'all mean, to get it out. I mean, because he doesn't seem to understand what junk is. He's cleaning up leaves and trash like that. He's not cleaning up the stuff that I took out of there.
Well, if we give this violation to you, you're going to have something to show him, but it's also going to be enforceable that the junk has to be gone.
Or they're gonna remove
Or
it.
there'll
Really,
be a
like anything that
penalty.
doesn't
Yeah.
belong outside, like that's all junk. Like all of it, really.
That's why I wanted him to come down here so y'all can tell him that. Because he doesn't seem to understand.
Is he here with you?
So do you
No,
ask
he's
him?
not here. He was supposed to come down here, but as soon as we got ready to go, he wanted to go in and jump in the shower so he could come down here.
Because you don't want to face the noise.
Of course, he wants us to pick the face.
Well, he's putting a lot of ownership on you, and honestly, that's not fair, because you're the one who's held responsible for the penalty, the liens that accumulate, et cetera. All the downstream impact weighs on you. So it's really unfortunate, and there will definitely be a motion to move for the lien today.
And
Is
Mr.
that-
Wallace, this will be on YouTube after the fact, if you can show it to your nephew and he can maybe understand the severity that way, what the board has said.
It's disappointing to me that a nephew would do that to his uncle and put him in such a position.
He does it to me and his father also. That's his father back there.
I'm really sorry to hear that.
But he had a stroke, so neither one of us can have stress. I've had a couple of heart attacks, so I don't want to argue with him. He's had a stroke, so he doesn't need to argue with him.
Well, maybe this will help you get the message through to him by having this.
We're going to send a copy of the order too, so that you can give it to your nephew.
All right.
Thank you so much for your time, Mr. Wallace.
Thank you for listening to me.
Recommendation?
Do you have a recommendation on a timeline?
Yes. Daniel Casman, Code Enforcement Inspector for the City of Clearwater. This is for, correct case number there, but for case number 35-22 for 409 South Martin Luther King Jr. Avenue. Violation of accumulation and placements of nuisances and lot clearing, requesting compliance on or before 5 days from the date the board renders its order, and we're asking the board to authorize the following: for the Code Compliance Division to take all reasonable actions, including entry into the property to abate and maintain the nuisance and charge the violator with the reasonable costs, which will become a lien on the property. And after 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with the reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
I'll second that.
All in favor?
Aye.
Do we have that date?
5
It'll-
days.
It'll be 5 days after you sign it.
Oh, so from signing,
Yeah.
okay.
Yeah.
And then you'll deliver that to Mr. Wallace?
I believe the clerk will send Mr. Wallace a
Seems
copy,
like-
and if it's not clear,
Right, we'll have two that goes, so we can
Okay.
Unfortunate situation, thank you.
thank you very much, Board.
Case 42-22, nuisance abatement lien for respondents Robert and Paulette Elliott at 1675 Algonquin Drive for lot clearing. Is there anyone here?
No, ma'am. The city is requesting a declaration of violation on this case.
Does anyone have any questions? Alright.
So for case, can we just do the declaration?
Yeah, just do their declaration.
So for case 42-22, I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Where are you?
A second.
We got a second.
All in favor?
Oh, you second? All in favor?
Aye.
I thought we were gonna listen to Mr. Odegaard.
Oh, you are?
Oh, okay.
I was getting ready. Ready for the next one?
For the next one.
Pardon?
Was there a vote on the motion? I'm sorry.
Yes.
Okay, thank you.
Aye. We're on this one. 7-4, yeah. Case 43-22, accept the nuisance abatement lien for respondents Laura Long at 1786 Murray Ave for lot clearing.
And Ms. Long is here.
Ms. Long, do you want to step to the podium and speak?
She was not.
Sorry, when I thought he was queuing up this one.
There you go.
I don't know what to say. I'm
Ma'am,
about,
hold on 1 second. I just need, no, come on up. It's okay. It's okay. I just need to swear you in. Do you swear or affirm to tell the truth throughout your entire testimony?
yes, I do.
Thank you.
And can you just state your name and address?
Laura Long, 1786 Murray Avenue, Clearwater, Florida 33755. I was doing a lot of yard sales, and I've cleaned it all up, but at this point in time, I'm about ready to lose my house, so I'll probably be homeless here shortly. I don't even know why I'm even here. I don't know.
Losing your house regarding not paying the mortgage or?
Yes, I'm financially behind, and I'm getting further and further behind. So,
So we'll take a look and see what the inspector says regarding this
All right,
property.
thank
Thank
you.
you.
Thank you.
Afternoon, Board. This is case 4322 at 1786 Murray Avenue. Number of violations at the property, it's just one. It's accumulation and placement of nuisances. Notice of violation was sent to Ms. Long on May the 11th, 2022 with a compliance date of May 23rd, 2022. I have not received the signed green card back. I did post the property also on May 11th. Just for an overview, this property is located west of Keene and south of Sunset Point, right here on Murray. When I first went out to the property on May 11th, this was actually initiated by multiple citizen complaints. I got 3 phone calls and 3 sets of complaints all submitted in the last month about this property. Just for clarification, Ms. Long has been holding yard sales since about 2011, and in the past 3 years, she's been cited 11 times for all the accumulation and placements of nuisances. So she's well aware of the ordinances. Like I said, when I went out to the property on May 11th, this was the condition. Again, she's just setting up everything outside in her front yard and in her driveway. And it's just a continuous junk and debris is just coming to the property.
This is the front yard?
This is the front yard. So here I posted the property saying that it all needed to be removed within 10 days. On the 17th, I went back out just to see if she'd made progress, which she had not. Everything was still in effect. Again, just a different view. Went back out on the 23rd. Again, everything is still sitting out at the property. This was her compliance date. Nothing had changed. So what we're going into and what the loophole that we keep running into with Ms. Long is we give her time to correct the violation. She'll pull stuff inside. As soon as that violation time period and the time that we've given her has passed, she'll just bring it right back out. And unfortunately, we have to start over again because we've already complied the case. So what I'm asking the board to do is to give us an abatement order now that Ms. Long is well aware of the time stipulations that she's been giving. Anytime that she puts nuisances and stuff back out there in the front yard, we can go out and abate it and remove it from the property.
Is there a,
Wouldn't that fall under
yard
repeat
sale?
violation though?
She's never been to code court before.
Oh.
Because we've always given her time to correct the violation, we just don't immediately go out and cite people. We give them time to correct the violation. If they come into compliance, then it starts over. So that's why we're at code board today.
Is there a yard sale permit for this part of the city?
No, there's not.
So
You don't have to pull a permit to have a yard sale. You're allowed to have 2 yard sales per calendar year. The problem is that Ms. Long has a continuous yard sale for 365 days.
Understood.
How do you keep track of yard sales if they don't have to pull a permit?
We just go out, we verify if there's something's going on. We also have weekend inspectors, so if we get complaints such as in this case where we think that people are having excessive yard sales, we'll schedule a weekend inspector. They'll go out, take pictures, verify it.
Okay, your recommendations?
Again, this is for case 4322. We're requesting compliance on or before 5 days from the date of the board renders its orders, and we're asking the board to authorize the following: for the Code Compliance Division to take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the violator with a reasonable cost, which will become a lien on the property. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
And Ms. Long has already made her comments, so,
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property to abate and maintain the nuisance and charge the respondent with a reasonable cost, which will become a lien on the property. If the costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
was it the second? All in favor?
Aye.
Aye. Motion passes. It for abatement liens. Any other comments? I now close this portion, public portion of the hearing.
You can adjourn. Yes.
Sure.